It's so good to be back with you. We're out of Tisha B'Av. We're out of the 9 days. We're listening to music. We got through our fast. As a matter of fact, it's like we've gone through that low point in the Jewish year. That's going to be a high point. Tisha B'Av, on the date on which the temples were destroyed, is also the date in the calendar on which the tradition holds the Messiah will, or perhaps has already been born. But now we start ramping up. This Friday we have a beautiful little holiday, Tu B'Av. It's not something we take off from work, but it's the Jewish Valentine's Day. And then we're halfway through the month of Av, and then we're moving toward Rosh Chodesh Elul, and Elul is the final month before Rosh Hashanah. In Elul, God comes sort of closer. God is in the field, as it says. The king is in the field. And, we're sort of starting to move toward the high holidays, but there's this beautiful anticipation and the idea that God wants us to crown him king. God wants us to make an atonement and be cleansed of our sins. So we're really now entering this beautiful upswing in the year. Okay, we didn't have a class on Saturday or Sunday because of the fast of Tisha B'Av. So we did a double daf on Friday, and we're going to do a double daf today. So lots to cover. Let's just quickly welcome everybody who's with us. Yehuda in South Carolina, Sharon in New Jersey, Steve and in New Hampshire, Bella in Florida, Shandor in the Bronx, Guy in Ohio, Nancy, North Carolina, Bill in Missouri, Dave in Indiana, Paul in the great Northwest, Franco in Trieste, Italy. Welcome, Franco. James in Indianapolis. James in Indianapolis. Where am I? It skipped on me. John in Maine, Lewis in Northern California. Kat says shalom. Renee in Indiana. Elvis in upstate New York. Paula, please prayers for a dear friend who died yesterday and another whose husband sadly took his life the evening before. Oh, so much woe. And during Tisha B'Av is what you're telling me. That is so sad. May their memories always be for their blessing. May the mourners be comforted. Sandy in Michigan, Christina in Texas. Over there on the YouTube side, John in Sedona, Lynn in North Texas, Aoife saying shalom. Welcome, everybody. That opening song was Ein Kelokenu from Eitan Katz singing a Shlomo Carlebach melody. We are in chapter 3. Facebook, you keep doing that to me. We are in chapter 3 of Tractate Kesubos. This is the 15th volume of the Talmud, generally speaking, the laws of marital contracts. But as we've seen, the sages will often make a digression in this volume. In chapter 2, laws of testimony, laws of evidence, who is credible and who is not. Here in chapter 3, we open the first Mishna looking at the law of the rapist and the seducer. Not the same topic at all. However, intersects with this law of marital contracts because we have this issue of, as our first Mishnah teaches, that certain people, if they rape or seduce a woman in a particular stage of her development, she's no longer a minor and she's not yet an adult, this small, short stage in her life when she's, quote, a young woman, one who rapes her, so he becomes liable to both pay a fine and marry her. Right? If she wants to marry him, and then he can never divorce her. He has to support her for the rest of his life. However, what if marriage is off the table? What if this victim of his terrible, heinous crime happens to be his sister, or she's a mamzer, or there's some other law that gets in the way and says he cannot marry her? So then that sages ask the question, well, if the punishment was he marries her and he pays a fine, but now he does not marry her, does that also mean that he doesn't pay the fine? Answer, no, he pays the fine. Now, this is a difficult body of law to people who are not at all familiar with Talmud study, because it almost sounds like, oh, this guy, rapes this woman, commits this horrific crime, traumatizes her perhaps for life, and he pays a fine. And that's it? Well, right now we're talking about one particular fine which is the fine related to the fact that he has rendered her not a virgin. And then when she gets married and enters a marital contract, she won't receive the same contract that she would have received if she had been a virgin, and therefore he has to compensate her for that. We are not discussing all the other punishments that accrue to him, at least not in that Mishnah. Now in our discussion, we are starting to talk a little bit more about all the other punishments that can accrue. Sometimes the death penalty, sometimes flogging, lashes, which can be a very severe penalty indeed, as we will discuss today. Also, when we talk about paying a fine, it sounds, just paying a fine. But when when you think about some of the recent court cases where damages are paid, it can be a huge amount of money that can sort of be a punishment that will, sort of stay with this guy maybe till the end of his days, if it's the kind of debt that he's going to incur in order to pay these damages. So there's just a lot more to it than we might be initially examining. And so you always have to be careful when we're discussing an issue, what law is being addressed, if it's, a tort or a crime. Are we addressing the crime in its completeness or just one aspect of the punishment? It doesn't mean there aren't other punishments. It doesn't mean that he's not liable to other kinds of damages or other kinds of punishment. It's that we're just talking about one particular aspect of it. Okay, we pick this up. In particular, the question that's going to keep coming up today is, okay, somebody who is liable to receive lashes, that he's going to be whipped by a court. And a whipping, you've seen in the movies, a whipping can be very, very severe. In fact, a whipping can be so severe that it kills the one being whipped. But if somebody is receiving lashes, does he also have the financial penalty, at least certain types of financial penalty? There's going to be a principle that often, no, it's one or the other. Either you get lashes or you pay the penalty. But there are exceptions to that, and then we're going to see what causes both to happen, and when only one of them is going to happen, which is it? Is it going to be lashes, or is it going to be the financial punishment? Now, on the one hand, somebody commits a terrible crime, and you're in a society where going to jail or prison for a bunch of years is actually just not one of the punishments that's on the table. So you would think, well, this guy committed a terrible crime, I want him to be whipped. But if he's only going to get whipped or pay damages, does it benefit the victim that this guy gets whipped, in public, maybe within an inch of his life? But does it help the victim? Maybe the victim would prefer to receive damages and somehow be made whole, or at least an attempt to be made whole by receiving, a substantial financial payment. These are the kinds of issues that are at play here. We pick this up at the bottom of 31b. The Mishnah continues. One who has forced relations with his sister, right? He's a real character. He rapes his sister. Or he rapes his father's sister, his aunt, or his mother's sister, or his wife's sister, or with his brother's wife, or his father's brother's wife after they are divorced, or with a menstruating woman. In all these cases, there is a fine paid. And the Gemara raised a contradiction from the following Mishnah in Makos, Tractate Makos 13a, which is about the law of flogging. And these people are flogged. One who has relations with his sister, or with his father's sister, or with his mother's sister, or with his wife's sister, or with his brother's wife, or with his father's brother's wife, or with a menstruating woman. Anyone who intentionally has relations with any of these women is punished with lashes. So if there's generally a principle that you either get flogged or you pay, we seem to have a contradiction between our Mishnah here in Tractate Kesubos, which says you pay, and this other Mishnah in Makos, which says you get lashes. Now we're in 32a. And since we maintain in general that one is not both flogged and liable to pay, if one receives lashes for having relations with his sister, why must he pay the fine as well? And Ula said, this is not difficult. Here, the law in the Mishnah is with regard to his sister, who is a young woman, right? She's hit puberty, but she's not a full adult yet, for whom one pays a fine and is not flogged. Whereas there, in that other Mishnah, the law is with regard to his sister, who is a grown woman, for whom one does not pay a fine, and therefore he gets lashes. This is according to Ula. So the Gemara asks, in the case of one who has relations with his sister, who is a grown woman, also, although he does not pay a fine, isn't there compensation for humiliation and degradation? Right, so now we're seeing that there's the Torah-imposed fine for rendering her not a virgin, and there's Torah-imposed damages of all different kinds. As we'll see, there's 5 categories of damages to which somebody who injures another could become liable. So 2 of those categories are humiliation and degradation. So he should be exempt from, it's actually it's one category, humiliation and degradation. He should be exempt from lashes in that case as well. And the Gemara answers there. The law in the Mishnah is with regard to his sister who is an imbecile, with regard to whom there's no humiliation or degradation beyond her status as an imbecile. In other words, this is somebody whose mental capacity is so diminished that she doesn't even know what's happened, doesn't realize that she's been embarrassed, publicly humiliated, etc. And the Gemara asks, but isn't there payment for pain, even in the rape of an imbecile? And the Gemara, that's another category. And the Gemara responds, the law is with regard to a seduced woman who's not entitled to payment for pain as she engaged in relations willingly. So there's a difference now between the case of seduction and the case of rape. So the Gemara comments, now that you have arrived at this explanation, that the Mishnah is referring to a seduced woman, the Mishnah can be understood even if you say it is referring to his sister, who is a young woman, this category where her father still has some authority over her, but not all. That's why it's one of these liminal cases where the law has a lot of nuance, and that's why remember, the sages will always focus on tough cases, even if they happen very infrequently in the real world, because that's where the law is difficult to determine. So the reason that the seducer does not pay the fine is that the law is with regard to one who is an orphan and a seduced woman. Were her father alive, he would receive the payment. Because the father died, the payment goes to her. Since she willingly participated in the relations, she relinquished her right to the payment, and the seducer is therefore liable to receive lashes. You see how this is a multi-step thing, right? Did I forget to light the candle? Thank you. Let's light up the darkness. We're in a hurry trying to move fast. Okay, right, so if it's an adult woman and you cause her damage in some form, so you owe the money to her. If it's rape and you take her, or even seduction, and you take her virginity, it's she that's been damaged. If it's a minor, right, then the payment is to her father, because her father, and as the ancient world, can't marry her off with the same marriage contract that she would have received otherwise. If she's in that in-between stage, still under the authority of her father, this is the case we're talking about in our Mishnah, so then the money would go to the father. But it's a case of seduction. The money would go to the father, but he's dead, so it would now go to her. But she participated in it willingly, so that takes the money off the table. Now that the money is not in play, the lashes come back into play, and this guy gets flogged. The Gemara comments, we did that. So the Gemara observes, apparently Ula maintains that in any case, where there is liability to both pay money and receive lashes, for example, one who rapes his sister who is a young woman in this in-between category. So there, in that situation, the rapist pays money, but he is not flogged. And the Gemara asks, from where does Ula derive this principle? And the Gemara answers, he derives it from the law of one who injures another. Now, just as with regard to one who injures another, where there is liability to both pay money for the injury and receive lashes for violating the prohibition from Deuteronomy 25:3, lest he continue to strike him, that's what you're going to give him lashes, lest this guy continue his violent ways. So lest he continue to strike him, you're going to administer lashes. So the law there is that one pays money, but is not flogged. Now you might think, well, wait a minute, you violated two different laws. There are two different transgressions here. One is you hurt somebody. And that's going to, as is going to come up in a moment, eye for an eye. right? Eye for an eye doesn't mean that if you put out a person's eye, they put out your eye. It means that you pay him all different kinds of damages for the injury that you caused him. You owe money. If you now, were violent against someone, there's a different law. So if the money is owed because of an eye for an eye, and the lashes are owed because lest this person continue to be violent toward the other, we're going to impose lashes from the court. You might think, okay, well, it's two different Torah prohibitions, therefore we do both punishments. You pay and you're flogged. But we have this principle, no, it's one or the other. So the Gemara answers, right? He derives it from the law that one who injures another, just as with regard to one who injures another, where there is liability to both pay money for the injury and receive lashes for violating, lest he continue to strike him. The law there is that one pays money but is not flogged. And so too, in any case where there is liability to both pay money and receive lashes, one pays money but is not flogged. Now the Gemara asks, what is the basis for the comparison between other cases and the case of one who injures another? This idea that one who rapes, somebody he's prohibited to marry, and he's going to pay damages but not be whipped for it. Why are we going to learn that out from the law of one who simply injures another person? Are these cases comparable? One who injures another cannot serve as a paradigm for cases of liability for both money and lashes, because the case of one who injures another is particularly stringent, as he is liable to pay 5 types of indemnity. And what are the 5 categories of damages? Injury, pain, medical costs, loss of livelihood, and humiliation. Now you can see that even in ancient times, in a rabbinic court, for certain kinds of tort, right, injury that you injured somebody, 5 different categories of payment. And if payment of money is a more lenient form of punishment than lashes, one could infer a fortiori, right, kal v'chomer, if in the stringent case of injuring another, one receives the more lenient punishment of paying money as opposed to receiving lashes, all the more so would he receive the more lenient punishment in less stringent cases. Nevertheless, one who injures another cannot serve as a paradigm for cases of liability for both money and lashes. And the reason is that there is also a lenient aspect with regard to injuring another, as it is permitted in departure from its norm in court. What does that mean? The court administers lashes, injuring those convicted. The leniency is that its application is selective. In other words, there is a time when you can injure someone else, namely when the court is going to injure a guilty party by whipping him. Now, rather, the Gemara states that Ula derives this principle from the law of false conspiring witnesses. We're not going to derive that if there's both financial damages and lashes, that we only do the financial damages from the law of injuring another, because that's a complex body of law. Let's instead look at the conspiring witnesses. These are witnesses who come as a pair and say that, so-and-so damaged another person, so-and-so killed another person, so-and-so claims to be a priest, but we know that he's not a priest. And then whatever it is that they're testifying about, it turns out that they're lying, and we can establish that they're lying because there's another pair of witnesses who say these 2 witnesses who claim to have seen what the defendant did at a certain time and place, we know they're lying because at that time, those 2 witnesses were at another place and we saw them there. That's called conspiring witnesses. Now, the punishment for conspiring witnesses is that they're going to receive the same punishment that the defendant would have received if he was convicted according to the testimony of the conspiring witnesses. Now, what happens with them? Just as with regard to conspiring witnesses, where there is liability to both pay money, if they falsely testified, to render one liable for payment, and receive lashes for violating the prohibition, you shall not bear false witness against your neighbor. Right? The punishment for bringing the false testimony is they're going to receive whatever punishment, and it might have been a financial punishment the defendant was going to get, but also because they lied to the court, they bore false witness. And the punishment for that is lashes. So it looks like the same action, their conspiracy to testify falsely and doing it in court, is going to result in both lashes and a financial payment. So just as with regard to conspiring witnesses, where there's liability to both pay money, if that's what the defendant would have had to do, and lashes because they bore false witness, and the law is that one pays money but is not flogged. So too, in any case where there is liability to both pay money and receive lashes, one pays money but is not flogged. Right? You might have thought that the conspiring witnesses both pay the money and get lashes, but they don't. If the underlying crime that they were trying to get the defendant convicted of was a money payment, they're going to have to make that payment. And they also should have received lashes for bearing false witness, but they don't get the lashes. They pay the fine or the damages, whatever they were going to make the defendant pay through their false testimony, but they don't get lashes. So that seems to be the proof text for why, when you're liable to both money damages and lashes, you only get the money damages. So the Gemara asks, what is the basis for the comparison of other cases to the case of conspiring witnesses? Conspiring witnesses cannot serve as a paradigm for cases of liability for both money and lashes because the case of conspiring witnesses is particularly stringent. It has a unique aspect as they do not require forewarning. As a rule, the courts administer punishment only to one who was forewarned not to perform the transgression. Right? You only actually get corporal punishment, whether execution or lashes, if right before you did the crime, somebody said to you, if you do that crime, you're going to be punished in the following way. It is a crime and you'll be punished if you do it. And then they do it in front of two witnesses. So the fact that this is not a requirement in the case of conspiring witnesses, they don't have to be warned right before they bear false witness as conspiring witnesses in front of the court. They're still going to get punished, even if the punishment is lashes. Therefore, no proof can be cited from the case of conspiring witnesses to other cases with regard to monetary payment instead of lashes. In other words, why would conspiring witnesses get lashes? Because what they're testifying about that the defendant did, the defendant would get lashes if he's convicted. In such a case, if they're proven to be conspiring witnesses, they get the lashes, right? And in such a case, they don't have to be warned that if you conspire falsely and, it's proven, then the lashes he would have got, you're going to get. They don't have to have that warning. They're going to get the lashes if it's proven that they were conspiring witnesses. And if payment of money is a more lenient form of punishment than lashes, the case of conspiring witnesses also has a lenient aspect, as they did not perform an action, but merely spoke. Just speaking isn't going to result in monetary damages, usually. That's what's being said here. But for conspiring witnesses, their action is speaking, and it will result in a heavy punishment. So rather, Ula derives the principle from both of them. He uses both the cases of one who injures another and of conspiring witnesses, and he uses them together to prove that you either get lashes or payment, and if you are liable to both, you pay, you don't get lashes. So the common denominator of both cases is that there is liability to both pay money and receive lashes, and the law is that one pays money but is not flogged. And so too, in any case where there is liability to both pay money and receive lashes, one pays money but is not flogged. And the Gemara asks, what is the basis for the comparison of other cases to the common denominator of causing injury and conspiring witnesses, in which both what they have in common is that you're liable to both money and lashes and you only pay the money? But how can we compare other cases to this common denominator as they have an element of stringency that does not exist in other prohibitions, in that one who injures another pays 5 types of indemnity and conspiring witnesses are flogged without forewarning? They have these 2 elements of stringency that don't exist in other cases. So how can we take their common denominator of 2 things that have stringencies that other matters don't have and now apply it to other matters? How can we do that? And if money, and especially how are we going to do that when payment of money is more lenient than lashes? And if payment of money is more lenient form of punishment than lashes, other cases cannot be derived from it. as they have an element of leniency that does not exist in other prohibitions. The prohibition in the case of one who injures another is selectively applied, as it is permitted in departure from the norm for a court to injure another when it's administering lashes, and the case of conspiring witnesses is lenient because they perform no action. So these two cases have stringencies that other cases don't have, and they both have leniencies that other cases don't have. So how are we going to extend this principle of if money and lashes, only money? How are we going to extend that to other cases when they're not really comparable? Now we're on 32b. So rather, Ula derives his principle that if money and lashes, you only pay the money. Rather, Ula derives the fact that one pays and is not flogged by means of a verbal analogy between the terms for, F-O-R, and for. This word for, that you're going to do something for something, that it appears in two laws that seem to have a link between them. How? The verse states with regard to rape, and the man who lay with her shall give to the father of the young woman, right? One who rapes a woman who's in that stage of life. She hit puberty. She's not an independent adult yet. One who lays with a young woman shall give to her father 50 shekels of silver, and to him she shall be as a wife, because tachat, right? It's because or for, F-O-R, but it's this word tachat. He tormented her. Deuteronomy 22:29. And it states there with regard to injury, an eye for an eye. Same word, tachat, right? An eye for an eye. Or she shall be to him as a wife, for he tormented her. The same word for, tachat, an eye for an eye. Eye and tachat, eye. Okay, so just as there, with regard to injury, one pays money and is not flogged, so too, in any case where there is liability to both pay money and receive lashes, one pays money but is not flogged. Now, it's just taken as a given here that we're familiar with the law of injuries, right, where it says an eye for an eye, a tooth for a tooth, etc. The sages have a long discussion in another part of the Talmud, the Bible, the Tanakh says an eye for an eye. So if somebody, does something either purposefully or negligent that results in another one losing his eye, maybe we should learn out from that the aggressor loses his eye. And there, at length, the sages prove that is not what the Torah means. And that's a very clear example, by the way, of why you need the Talmud, right? Why you need the oral tradition. Because if you only read the written Torah, you might assume that an eye for an eye means you put out the aggressor's eye. But that is not what it means. We have a long tradition and lengthy proofs of why it doesn't mean that. So, since there is financial damages being paid, you might have thought, okay, well, we're not going to take out his eye, but maybe since he disfigured this other person, we should at least flog him. We should at least whip, give lashes to the aggressor. And there it's also proven no, if financial damages, only financial damages. In proposing a different resolution to the apparent contradiction between the Mishnah here that rules that one pays a fine for raping a sister, and the Mishnah in Tractate Makos that rules that one is flogged in that case, Rabbi Yochanan said, right, we've been looking at Ula's approach to this, now Rabbi Yochanan, even if you say that both Mishnayos are referring to his sister who is a young woman, there it is referring to a case where the witnesses forewarned him, and therefore the rapist is flogged. And here it is referring to a case where witnesses did not forewarn him. Since no lashes are administered without forewarning, the rapist pays the fine. And so it almost seems like, well, it's not the crime itself that is going to give rise to payment for damages over flogging, but rather the circumstances, right? In other words, if he was warned, don't rape her, and if you do, you're going to be subject to lashes, and he does it anyway, so then he receives lashes. And he doesn't pay her. But if he doesn't receive such a warning, which would seem to be by far the more typical situation, then the lashes are not possible, and he pays the damages. Seems to be, it's not about the emotional content of this. It's just kind of legal logic, and it seems to be a pretty logical way to approach it from Rabbi Yochanan. The Gemara observes, so apparently Rabbi Yochanan maintains that in any case where there is liability to both pay money and receive lashes, and the witnesses forewarn him, so then he is flogged, and he does not pay money. And the Gemara asks, from where does Rabbi Yochanan derive this principle? And the Gemara explains that he derives it from that which the verse states with regard to one sentenced to lashes in the court. The judge shall cause him to lie down and to be beaten before him, before the judge, according to the measure of his wickedness. Deuteronomy 25:2, from which it is inferred, for one act of wickedness, i.e. punishment, you can render him liable. But you cannot render him liable for 2 acts of wickedness. And juxtaposed to this it states, 40 he shall strike him, indicating that the punishment that is administered when one is liable to receive 2 punishments is lashes and not payment. Right? So that verse in the Torah seems to indicate that somebody who's deserving of lashes, he's only going to get lashes, he's not going to also get a financial penalty. And it is preferable that he gets lashes. That's how Rabbi Yochanan is reading it. And when he gets lashes, he gets 40. 40 lashes administered by a real whipper. I can't think of the word for the guy who does that. Is a very, very painful punishment, and in the wrong hands could even kill a person. Now the Gemara asks, and what of the case of one who injures another, where there is liability to both pay money and receive lashes? In which case one pays money, as we've established, but he is not flogged. What does Rabbi Yochanan say about that? Unless you say that this applies only when the witnesses did not forewarn him, but if they did forewarn him before he struck his friend, he is flogged and he doesn't pay money. But didn't Rabbi Ami say that Rabbi Yochanan himself said, if one struck another with a blow that does not cause damage that amounts to the value of a peruta, he is flogged, right? So peruta is like a penny. And so what they're saying here is, maybe he struck a blow that you can't measure a financial consequence of it. He did something that, like what he did, doesn't really have measurable financial consequences. So in that case, we whip him. But if it was measurable, right, which would seem to be almost any kind of assault and battery, right, where if somebody hits you and he does it in a public place, so there's humiliation. If it hurt you, there's pain. If you're injured, there's injury. If there's loss of livelihood, if there's medical costs, etc. So if there's some kind of measurable damages, it seems like Rabbi Yochanan would say, so whipping is what we do if there's no measurable damages. But if there's measurable damages, then the victim gets the damages, because he'd certainly prefer to receive the damages than to see the aggressor flogged. I mean, I'm sure he'd like to, if he was hit, see that guy, gets punished publicly and is humiliated and is whipped, etc. But it doesn't really benefit him other than his sense of revenge, as it were, of justice perhaps. But if there's measurable damages, it sounds like in that teaching there, Rabbi Yochanan says, if the damages are measurable, the victim gets the damages, and we don't flog. So the Gemara asks, what are the circumstances of that case? If it is a case where the witnesses did not forewarn him, why is he flogged? No lashes are administered without forewarning. Rather, obviously, it is a case where they did forewarn him, and the reason he is flogged is that there is no damage that amounts to the value of a peruta. The damages are not quantifiable, and so the Gemara infers, however, if there is damage that amounts to the value of a peruta, he pays the money and is not flogged, even though he was forewarned. So it would seem that you can't say that Rabbi Yochanan prefers lashes to damages, because here's a case where he says, even though the aggressor was forewarned, when he hurt the other man, he created measurable damages, and so the victim gets the damages and the aggressor doesn't get flogged. So the Gemara answers that the fact that conspiring witnesses pay money can be explained in accordance with that which Rabbi Ilya said in a different context. Right? We're switching away from Rabbi Yochanan. We're still looking for this proof that if you're liable to both flogging and money damages, it's going to be money damages. And where are we going to learn that out from? The case of conspiring witnesses. So, says Rabbi Ilya, the Torah explicitly amplified the case of conspiring witnesses to include liability for payment. The Torah employed language indicating that the conspiring witnesses who testified falsely, in order to render one liable for payment, must pay the sum that the defendant would have had to pay, and they are not flogged. Here too, with regard to injury, the Torah explicitly amplified the case of one who injures another to include liability for payment. And so the Gemara asks, and where is this statement of Rabbi Ilya stated? And the Gemara answers that it is stated concerning this Mishnah in Tractate Makos, the law of flogging, on page 4a. If witnesses said, we testify that so-and-so owes another person 200 dinars, and these witnesses were discovered to be conspiring witnesses, they are flogged and pay as the source that brings them to liability to receive lashes does not bring them to liability for payment. Each liability has an independent source. The source for lashes is, you shall not bear false witness against your neighbor, while the source for payment is, you shall do unto him as he conspired to do to another. And this is the statement of Rabbi Meir. That was the minority opinion in Tractate Makos. And the rabbis say in that tractate, anyone who pays is not flogged. And with regard to the Mishnah, the Gemara asks, let us say, on the contrary, that anyone who is flogged does not pay. Rabbi Ilya said, the Torah explicitly amplified the case of conspiring witnesses for payment, not lashes. The Gemara asks, where did the Torah amplify the case of conspiring witnesses? The Gemara explains, now, since it states with regard to conspiring witnesses, and you shall do unto him as he conspired to do unto his brother, why do I require the Torah to state in his punishment a hand for a hand, Deuteronomy 19:21? This indicates that the punishment that takes precedence is one in which there is an item that is given from hand to hand. And what is that item? It is money. And so the same can be said with regard to one who injures another. Now, since it states, and a man who places a blemish upon his counterpart, as he has done so shall be done to him, Leviticus 24:19. Why do I require the Torah to state, as one who places blemish upon a man, so shall be placed upon him, Yochanan, Leviticus 24:20. And this teaches that this is referring to an item that involves giving, netina, same word as Yochanan. And what is that item? It is money. So there seems to be references to money even in the laws of, rectifying injuries and damages. So the Gemara asks, and Rabbi Yochanan, what is the reason that he did not say the same law as Ula? That where there is liability to both pay money and receive lashes, one pays money, but is not flogged. And the Gemara answers, if so, if that were the case, you have rendered moot the prohibition, the nakedness of your sister, you shall not uncover, Leviticus 18:9. In that, contrary to the standard prohibitions, no lashes would be administered for its violation. And so the Gemara asks, based on that reasoning, and now we're on page 33a, the same would hold true for one who injures another as well. If so, if he pays and is not lashed, you have rendered moot the prohibition. 40, he shall strike him. He shall not exceed, lest if he should exceed. Deuteronomy 25:3. In other words, the Torah seems to be saying in certain situations, you flog. You're supposed to flog this person. He committed a terrible crime. He deserves lashes. Either he lied in court or he raped his sister. He gets lashes. The fact that this person also becomes liable to financial damages, why should that excuse him getting flogged? Right? He violated two separate transgressions. He should have to, be accountable for both. If he owes financial damages, he owes financial damages. If he deserves lashes, he gets the lashes. Why are we going to say it's one or the other? And the same would hold true for conspiring witnesses as well. If so, you have rendered moot the verse interpreted as addressing the matter of conspiring witnesses, and it shall be the wicked man deserves to be flogged. So rather, with regard to conspiring witnesses, that verse can be fulfilled in the case of the son of a divorcee or the son of a chalutza, if witnesses testify that a priest is the son of a divorcee or a chalutza, so he's a disqualified priest, and they were discovered to be conspiring witnesses, well, then there is no payment, and they are flogged. You can't measure, what is the financial damage of saying that somebody is a disqualified priest when he isn't. So it would seem, okay, there, we don't have financial damages, you flog. And that's a case where the conspiring witnesses need to be flogged, but where in other situations where there's liability for both payment and whipping, you do the payment, right? So we haven't rendered the Torah verse moot that says there's flogging. It's just that there's limited situations where you would apply it. Now, with regard to one who injures another as well, the verse can be fulfilled in the case where he struck him with a blow that does not cause damage amounting to the value of a peruta. Again, you hurt somebody, but somehow there's no financial measuring of the blow that you struck. So instead, we whip you. So the Gemara raises a difficulty. If so, with regard to one sister as well, the lashes can be fulfilled in the case of one who had forced relations with his sister, who is a grown woman. Since there is no fine in that case, because the Torah seems to stipulate the fine for one who rapes a woman who is a young woman, not an adult woman. And in the case of the adult woman, this could either be lashes or death penalty. Since there is no fine in that case, he is flogged, and therefore the verse is not rendered moot. So there is situations where you flog, even though there's also financial repercussions. And the Gemara answers, Rabbi Yochanan could have said to you that he does not agree with Ula because this verse, because he tormented her, the rapist, is not available for a verbal analogy because Rabbi Yochanan requires it to derive in accordance with that which Abaye said. As Abaye said that the verse states the fine of 50 dinar is payment because he tormented her. By inference, one may conclude that beyond the fine, there is compensation also for humiliation and degradation. There's other kinds of damages. The 50 dinar is only specifically for the rape. But if in raping her, he humiliated her, he hurt her, he put her in the hospital, he caused her to lose livelihood, etc., he's also going to have to pay damages for that. So the Gemara asks, and Ula, who uses this verse to derive a verbal analogy, from where does he derive the law stated by Abaye? And the Gemara answers, well, he derives it from the statement of Rava, who derives that law from the same verse. As Rava said that the verse states, and the man who lay with her shall give to the father of the young woman 50 shekels of silver. The superfluous phrase, who lay with her, teaches that it is for the pleasure of lying with her that he pays 50 shekels, i.e. 50 sela, and by inference, one may conclude that beyond the fine, there is compensation for humiliation and degradation. Rabbi Eliezer says, the reason that conspiring witnesses pay money but are not flogged, this is the underlying question that we're working our way around and around. Why is it that if there's financial liability and lashes, we only impose the financial liability? We're still deriving how we know that. Rabbi Eliezer says, the reason that conspiring witnesses pay money but are not flogged is due to the fact that they are not subject to forewarning. And without forewarning, there are no lashes. And Rava said, no, that this is true, since there is no practical manner to forewarn them, as when would we forewarn the conspiring witnesses? Perhaps let us forewarn them initially, before they come to testify. In that case, the forewarning would be ineffective because they could say, we forgot the forewarning. Right? The warning before you receive lashes or capital punishment for a crime has to happen right before you commit the crime. Right? Testimony takes a while. So when is it that they're going to be warned? Is it before they arrange to come to court and give their testimony? Well, by the time they're actually giving the testimony, it could be minutes, hours, days later. So it's not immediately before. And they could say, well, we forgot the warning. So in that case, let us forewarn them at the moment of the action, meaning just before they testify. But in that case, they will leave and not testify at all, as concern for potential repercussions will intimidate them into silence. In other words, people who are honest witnesses might be put off by a really harsh warning that you might be subject to the same penalty as a defendant in this case. And they might think, well, we're not trying to lie, but what if we made a mistake and we're proven wrong? And that might intimidate too many witnesses. Or let us forewarn them at the end of their testimony. In that case, that which was. At the end of their testimony, it's too late. You have to warn somebody before they commit the crime that's going to result in liability. Now, Abaye strongly objects to this. He says, and let us warn them within an interval equivalent to the time of speaking during the brief period after they completed their statements, at which time the testimony is not yet considered to have concluded. Right before they finish, when they seem to be winding up, you say, are you sure that everything you have said is true? Because if it turns out that you're lying, you're going to receive the punishment that the defendant would have received. So that would seem a good place to put that warning. Rav Acha, the son of Rav Ika, also strongly objects to this. He says, let us forewarn them initially before they testify and gesture to them during the actual testimony, reminding them of the forewarning, so they will be unable to claim that they forgot it. both of these people, Abaye and Rav Ika, are saying, what are you talking about? You can't forewarn witnesses and they still can receive corporal punishment. Sure, you can warn them. Abaye then said, that which I stated is not a significant matter. Instead, if it enters your mind that conspiring witnesses require forewarning, when we do not forewarn them, we do not kill them. However, is there a matter in which they sought to kill the defendant without forewarning him, as their testimony was false, and in order to punish them, they require forewarning? Don't we require that their punishment reflect the verse, and you shall do unto him as he conspired to do unto his brother? They didn't warn the defendant that they're lying about, that they're trying to give conspiring testimony that's going to result in him receiving the death penalty. And if we prove that that's what they're doing, it doesn't matter whether we warned them or not. They didn't warn the defendant. We don't need to warn them. And if we prove that they're lying, they're going to receive the death penalty that they sought to unleash on the defendant. So Rav Sama, the son of Rav Yirmiyah, strongly objects to this. However, if what you say is so, when witnesses falsely accuse a priest of being the son of a divorcee or the son of a chalutza, as their punishment is not amplified from the verse as he conspired, but rather they are punished for violating the prohibition, you shall not bear false witness against your neighbor, so then let them require forewarning. Right? If they're not testifying in a case where if it's proved, if their testimony proves the matter that the defendant will receive lashes or the death penalty, rather they're testifying about like whether a person is a priest or not, are we not going to give them lashes when we prove that they are conspiring witnesses? So since what the underlying issue is not one of receiving lashes, but they might receive lashes for bearing false testimony, so let's warn them and require forewarning before we impose lashes upon them. So the Gemara answers that the verse states, you shall have one manner of law, meaning that there must be a law equal for all of you. Since in standard cases of conspiring witnesses, no forewarning is required, like where they're trying to, unleash the death penalty on the defendant, then even in exceptional cases like testimony that a priest is not a priest, forewarning also is not required. New subject. Rav Shesha, the son of Rav Edi, said, the fact that in the case of one who injures another as well, he pays money and is not flogged, is derived not by means of a verbal analogy, but rather from here. If men quarrel and hurt a pregnant woman so that her child departs from her, so that she miscarries, and yet no harm follow, he shall be punished as imposed upon him by the woman's husband. And Rabbi Elazar said, the verse is speaking of a quarrel that involves death, i.e., these men sought to kill each other, as it is written, and if any harm follow, then you shall give a soul for a soul. So they've just said a lot. Now the Gemara itself is going to unpack that. What are the circumstances of this case? If they did not forewarn one not to kill the other, why is he killed if the death of his opponent ensues? How can you apply the death penalty? It's almost like the death penalty would never be imposed, and in practice it almost never was, because it has to be right before one kills the other. You say to him, if you kill that guy, you're going to be subject to the death penalty. And then he did it anyway, immediately after the warning, and there were two witnesses who saw it, right? That's the only case where there's going to be a death penalty. But is that the only case? Rather, obviously, it is a case where they forewarned him, and the principle is that one who is forewarned with regard to a severe matter, like murdering his counterpart, is considered forewarned with regard to a lesser matter, like injuring his counterpart. And although he is forewarned against injuring another, which violates a prohibition and is punishable by lashes, the merciful one states, and yet no harm follow, he shall be punished, indicating that one pays and is not flogged. So Rav Ashi strongly objects to this proof. First of all, with regard to your initial assumption, from where do you ascertain that one who is forewarned with regard to a severe matter is also considered forewarned with regard to a lesser matter? Perhaps he is not considered forewarned. If you say to somebody, if you kill that guy, you're going to be subject to the death penalty. And then, so he doesn't kill the guy, he just punches him and hurts him. Is he considered forewarned that if you injure him, you're going to be liable to lashes or to payment for the injury? Payment for the injury doesn't require forewarning. But lashes? Is he considered forewarned with respect to lashes? And for injuring another, maybe not. Maybe you only warned him about murder and capital punishment, but you didn't say anything about injury and lashes. Perhaps he is not considered forewarned with regard to the lesser matter. So furthermore, even if you say that one is in fact forewarned with regard to a lesser matter, from where do you ascertain that the death penalty is a more severe punishment than lashes? Now we're in 33b. Isn't that a great little Talmudic reversal of logic? We just assume that lashes is a lighter punishment than execution. I mean, obviously that's a pretty good assumption, but maybe not. Is there a situation where giving somebody lashes is actually less severe than executing him? 33b. Perhaps the punishment of lashes is more severe than the death penalty. As Rav said, in the book of Daniel, chapter 3, had they flogged Hananiah, Mishael, and Azariah, instead of casting them into the fiery furnace, now they were saved by a miracle from God, but the king, I think it was Nebuchadnezzar, who threw them in, expected them to die, right? So had the king cast them into the fiery furnace, had the king decided to whip them instead of throwing them into the furnace, then these three would have been induced to worship the graven image. See, you're supposed to accept the death penalty rather than commit idolatry. And that's what they did. They said, then throw us in the furnace. They were saved by a miracle, but they were willing to take the death penalty. Why? Because the death penalty is better than being tortured into finally bowing down to the idol. Right? If they were tortured with the idea that they're going to be whipped until they bow to the idol, they might eventually give in, and they themselves would prefer the death penalty to lashes in such a situation. Apparently, the punishment of lashes is more severe than death. So Rav Sama, at least in that case, Rav Sama, the son of Rav Ashi, said to Rav Ashi, and some say that Rav Sama, the son of Rav Ashi, said to Rav Ashi, what is the difference? I don't care what just happened. Whatever. So Rav Sama, the son of Rav Ashi, said to Rav Ashi, and is there no difference to you between flogging that has a limit? Because the Torah says if you flog somebody, it's 40 lashes max, which is a less severe punishment, and flogging that does not have a limit, right? Flogging to induce compliance, either at the hands of some other court than a Torah court, than a rabbinic court, or in a certain situation, for example, where it says we compel him to do such and such, like a man who refuses to give his wife a divorce in ancient times, he could be tortured by the court to give her the divorce. And if he refuses, they can keep whipping him even beyond the 40 lashes. So with regard to the basic proof that the case of the two men quarreling, Rav Yaakov from Nehar Pikod strongly objects to this. This works out well according to the opinion of the rabbis, who said that the verse, and you shall give a soul for a soul, is referring to an actual life, and that if he caused a woman's death, he is executed. Right? So there was the case before two men are fighting, and while they're fighting with each other, they're involved in violent behavior, and it results in accidentally striking a woman. They didn't mean to strike the woman who was standing nearby, but they did in the process of committing a violent act against some other guy. So they were engaged in violence, even though it wasn't intended to hurt this woman. So one question is, well, if she was pregnant and he causes her to miscarry, separate question. What if he hurt her and she's injured and it's unclear whether she will die or not from that injury? Then the Torah goes on to say, if she survives for a certain amount of time, so that you can say, well, this injury was not the proximate cause of her death, which comes later, then this guy is not a murderer. But if she dies within a certain amount of time and it's clear that, well, she might have lingered for a little while, but it was that blow that caused the death, then he is a murderer. And how do we define that? Says the Torah, if he rises and walks outside with his staff, he who struck him is absolved. Exodus 21:19. And could it enter your mind that this victim is walking in the marketplace and the aggressor is executed as a murderer? Rather, the verse teaches that one imprisons the aggressor while the injured party recuperates. And if he dies due to the blow he received, then we kill the aggressor. And if he does not die, If the victim does not die and he recovers, then the aggressor's punishment is based on the verse. His loss of livelihood he shall give, and he shall cause him to be thoroughly healed. Pain and suffering, medical damages, loss of livelihood, etc. So the Gemara elaborates, what are the circumstances? If the witnesses did not forewarn him, why is the offender killed if the victim dies? Rather, obviously, it is a case where the witnesses forewarned him, and one who is forewarned for a severe matter, such as the potential death penalty, is also considered forewarned for the lesser matter of injuring another, for which he is liable to be flogged, and nevertheless, the merciful one states, his loss of livelihood he shall give, he shall cause him to be thoroughly healed. So apparently, despite his liability to be flogged, he pays and is not flogged. Long-winded way of deriving when you're liable to damages and lashings and whipping and lashes, you pay and you are not flogged. So Rav Ashi strongly objects. And we're getting near the end of what I can cover today in our amount of time. So if you've got questions or comments, get them in. So Rav Ashi strongly objects to this proof. First of all, with regard to your initial assumption, from where do you ascertain that one who is forewarned with regard to a severe matter is forewarned with regard to a lesser matter? Perhaps he is not considered forewarned with regard to the lesser matter. Furthermore, even if you say that one is in fact forewarned with regard to a lesser matter, from where do you ascertain that the death penalty is a more severe punishment than lashes? We saw that case from Daniel. Perhaps the punishment of lashes is more severe. As Rav said, had they flogged Hananiah, Mishael, and Azariah, instead of casting them into the fiery furnace, they would have been induced to idol worship. And so it was better for them to receive the death penalty. So apparently the punishment of lashes is more severe than death, at least in one case, which would undermine the general principle. So Rav Sama, the son of Rav Ashi, said to Rav Ashi, and some say Rav Sana, the son of Rav Ashi, to Rav Ashi, and the set is implied. And is there no difference to you between flogging that has a limit, i.e. 40 lashes by Torah law, which is a less severe punishment, and flogging that does not have a limit, i.e. flogging administered to induce compliance, which is more severe? And Rav Mari strongly objects to this proof that one pays and is not flogged. From where do you ascertain that this is referring to one who struck another intentionally, and that the verse, he who struck him shall be absolved, means that he shall be absolved of the death penalty? Perhaps the verse is referring to one who struck another unwittingly, and the verse means that he shall be absolved of exile to a city of refuge. So in that case, there's no forewarning for the manslaughterer, who is exiled to the city of refuge. There's no warning, is not part of that body of law. So in that case, there's no forewarning. Therefore, no proof may be cited from here that one who injures another pays and is not flogged. And the Gemara concludes, this is difficult, and no proof may be cited from here. We're going to stop there. We're just a few paragraphs away from the end of page 33b. So please read that on your own, as I did earlier, and tomorrow we'll pick it up near the very bottom of 33b or near the top of 34a. But the bottom line is, that is the law. When you're subject to flogging and damages, you pay damages, with some very few exceptions where you might do both or get flogged instead. But generally speaking, subject to flogging and damages, you pay damages. Okay. Questions or comments on pages 33 and 34? I'm sorry, pages 32 and 33. Lesiuk and Eugenia. What happened to Tamar, who was raped by her half-brother? I'm sorry, are we talking about a different Tamar than Judah and Tamar? Like, Tamar had a husband who died, and then his brother married her, but didn't want to impregnate her so that the son would accrue to the merit of his brother. And then he died. And then she tricked her father-in-law into sleeping with her, and eventually he married her. And that actually is the union of that eventually produced the line of King David. Is there another Tamar? I'm confused. Somebody will help me. We'll come back to that. Sharon. Okay, we're talking about a different Tamar. Thank you. Sharon says Amnon is that son. He rapes Tamar, his half-sister, and then later hates her. Her brother Absalom kills Amnon, and Absalom is later killed by David's guards. Good. Thank you for clarifying that. My memory just spaced on that. Yes, so here we're talking about the sons of King David, right? Many generations later than the original Tamar. Right, so Amnon rapes Tamar, his own half-sister, and then, right, like, because he's so in love with her, and he's so in love with her, and he wants to marry her, and he wants to seduce her, and he wants her to sleep with him, and she's like, no, you're my brother, it's disgusting. He finally rapes her, and then instead of marrying her, he's disgusted because she reminds him of the evil that he did, right? And then her full brother, his half-brother, Absalom, kills Amnon, right? So now, but also Absalom engaged in an extrajudicial killing. This is going to create a big problem in the family, and is part of the, the melodrama, the soap opera that eventually sees Absalom trying to, usurp the throne of his father, King David. But that's a whole other thing. So I guess what you're asking is, why was he executed? I mean, the fact that Absalom killed him, that's an act of vengeance, right? That was not a court case, as it were. So it's not like the laws of the sages and the Torah were applied in that case. But if we examine that case more carefully, there'd be a lot to say about it. Sharon, it does seem that we hear all about what the punishment to the rapist is, but not real clear about what happens to the sister. It doesn't seem like the son would compensate their common father, right? And so that's why they're also distinguishing between the young woman and the adult woman. And in no way have we been exhaustive about, well, if God forbid a brother raped his sister, what is the outcome? What damages does he owe? Is he whipped or not? There's just a lot more to it. We're only looking at one aspect of the question. Okay, and that's what I've got for us today. With God's help, we'll be together again tomorrow. We'll just do a single page. It'll seem like a breeze. When we gather at 6 p.m. Pacific to do page 34 here in chapter 3, continuing our discussion of the first Mishna here in chapter 3. Have a great night.